Good morning and welcome to the Historic Courthouse. I am J.P. Howard. I'm joined by Judge V.J. Shanker and Judge Vanessa Ruiz for this morning's calendar, where we have one case on the docket, CARRUTH versus United States, 23 CF 387. I was going to ask the order, but Mr. Ryder, it looks like you're going first.
Yes. Good morning, Your Honors.
Would you like to save any time for rebuttal?
About 1 minute. David Ryder on behalf of Mr. CARRUTH. With the court's permission and due to time efficiency, I'd like to concentrate my half of the argument on the Sixth Amendment rights and allow amicus PDS counsel to address those issues involving the Second Amendment. But it is Mr. CARRUTH's position that the trial court violated his Sixth Amendment rights and the convictions violated his Second Amendment rights. It is Mr. CARRUTH's position that the trial court's order not to discuss his testimony, including with his counsel, during a significant break in the proceedings, violated his Sixth Amendment right to full functioning assistance of counsel. It is our belief that that position is consistent with Perry, Getters, and this court's own holding in both in Jackson, Martin, and Petty.
So, counsel, assuming that we agreed with you, where would you draw the line at what's an acceptable restriction and what's not?
I think that is the issue. I think the Second Amendment grants or shall, the words are shall be granted assistance of counsel. And the issue here is that, as was argued in, and I know the United States has filed a letter on it in the Villarreal case, is that their position, as their position was in the Perry case, was that, look, the truth-seeking functions of the trial have to be maintained. So when a defendant takes a break on his testimony, he can't discuss his testimony with anyone, including his counsel. We disagree because, as the United States argued in the Villarreal case, is that they're trying to protect against the management and coaching of testimony of the defendant. The real issue here today, and quite frankly, as it was in the Villarreal argument, is that the terms coaching and management cannot be defined in a Sixth Amendment context. I think the best examples that were brought up during the argument was that if coaching and management means a defense attorney cannot tell the defendant, please slow down, you're talking too fast, please speak up, as so often happens, the jury can't hear you, or please stop mentioning prohibited evidence in violation of the court's order, or finally, and just as important, you know, sir, it's time to take a plea, and let me tell you why. A failure of a counsel to do that invites ineffective assistance of counsel.
But then that seems to be an all or none argument, at least a principal argument that isn't conducive to a line then. I mean, why would it not be the case then that a defendant testifying, or any witness, but let's say a defendant well, I guess for Sixth Amendment purpose, we'll say the defendant can't say, Your Honor, I'm getting hammered here, I need to consult with my attorney.
Well,
then
sorry.
Counsel requests a 2-minute recess to discuss the testimony. I mean, that seems to be consistent with what you're saying the Sixth Amendment allows.
No, I'm not saying that. In other words, if a witness is on the stand or a defendant is on the stand, he can't say, unless there's some other Fifth Amendment issue or something like that, he can't say, I need to speak to counsel. But if there is a break,
but why not?
Well, I think that goes to the consistency and fairness of all the parties. But you bring up a point, and that is, why should a defendant be able to do that? The Sixth Amendment says that the right of counsel shall be granted to an accused. The fact of the matter is, the law treats witnesses differently.
Right. So why wouldn't a defendant be able to say, I need to speak to my attorney right now, I need a recess?
I'm not quite sure about that, but if there was a break in the testimony and a significant break, that is a lunchtime, and this court has ruled that a lunchtime is a significant break in the proceedings where one would expect important legal discussions to take place. But I'm sorry, Your Honor, what was the?
Why should the right to consult your counsel hinge on whether there is a scheduled break or you want a break because of something that is happening? Are you saying that there's just a balancing of, efficiency and just good order in the courtroom? I mean, it's hard to understand why, as Judge Shanker says, if you have that right to consult with your counsel, why that you wouldn't be able to do that. To just, you called the break.
Right.
And maybe you could be told yes, but keep it short because, if not, you're going to disrupt the trial.
That is a possibility. Although if the court is looking for a line in what can and can't be discussed, again, it's been mentioned in the case law that during any type of break, or it's a break, again, we're looking at the Villarreal argument, and it's now looking like the Supreme Court is not so much looking at the duration of the break. That's not determinative, but what is the substance of the discussions. So long as an attorney, and this is about what we feel the best line you can get, so long as the defense attorney does not try to change testimony, suborn perjury, or violate the code of professional ethics, the defendant has a right to, and that's how it's defined, a full
So then
function.
looking at the record in this case,
Mhm.
okay, first I want to ask you about two
Sure.
things. You said a significant break and this was a lunch break. And you're saying a lunch break is by definition significant for these purposes, is that?
Yes, that would follow this court's decision in Jackson.
No. The attorney, the defense counsel in this case, when told not to have a discussion with his client, first said something like, I know I can't coach him, but
Mhm.
then kind of took that back. And he said, no, he has an absolute right to talk to his lawyer.
Yes, Your Honor. And actually, that's what makes this case different from the Villarreal case.
Mhm.
In Villarreal, it was a qualified order. You can't talk about your testimony, but you can talk about other things. It's our position that this was a total ban here, looking in the context, because once the prosecution asked for the rule on witnesses, the court said, don't discuss your testimony. And at that point, the defense counsel said on the record, well, wait a minute, I have trial strategy and other important legal issues. And that order prevented him from doing so. So if one were to look at the last words that the court gave in this instance, don't discuss your testimony with anyone, I think it's a safe interpretation here that the court was ordering a total ban on communications during this break.
I think,
Concerning testimony.
Concerning testimony and anything else. In other words, he could,
Says don't discuss your testimony.
right, but also the order was that defense counsel made clear, I need to discuss trial strategy, but felt he could not do so with this court's order. The trial court never explained further, just said, sort of brusquely got up and said, don't discuss your testimony with anyone. I think this court's going to have to look at the context of the transcripts of what took place, because that is a demarcation point as why Villarreal's qualified order doesn't apply.
But if there's had been a qualified order, if what the trial judge said, and it would reasonably be understood as saying, don't discuss testimony during this 1 hour. I don't think we know from the record exactly how long this lunch break was. What then? What's your
Well,
position there?
it's our position, just following Getters, Perry, and this court's own holdings. It is impossible to distinguish discussions of testimony from general discussions of trial strategy. It's just not definable. As was brought up in the Villarreal argument, the defense attorney said it's a Rorschach test. And because of that, historically, this court has always gone to the side of the Sixth Amendment. And so long as a defense attorney does not again suborn perjury, try to change a witness's testimony, or violate the code of professional ethics, the defendant has a right to, again, the definition, what's full functional assistance of counsel?
But then we'd have to see if the Supreme Court in Villarreal does anything with Perry, right? I mean, if it doesn't, the plain language from Perry is there is no constitutional right for a testifying defendant to consult with his or her attorney while testifying. That's the direct language from Perry.
Right, but as we're seeing from the Villarreal, it's not the break that is the determinative issue. It's the substance of the discussions. So again, Villarreal still doesn't apply for this specific case because it's our position that this was a total ban on testimony, including talking about, hey, I want to talk about a plea. This attorney felt it was clear on its face that this court, that is the trial court, ordered him, don't talk, period. I see my time is up, but if the court has additional questions,
Counsel, I'd like to ask you quickly. PDS is arguing as amicus next, but
yes,
am I right that your client's position is that the court should grant the government's motion to vacate the the long rifle conviction?
yes, sir. I'm in an interesting position, one that I have not been in before. But yes, we don't oppose the dismissal. However, if the court needs to decide the Second Amendment issue, and we do feel the statute is unconstitutional based on the Brewer text and history test, because there is no right to self-defense. So, but yes, that is our answer.
Your answer is that we should vacate the conviction.
Our position is
Obviously
that if
your
the
client
United
obviously
States,
wants that.
right,
Yeah.
if the United States wanted to dismiss it, we're not opposed. But if the court decides that this is unconstitutional, which we believe this court should, I also don't oppose that. So it's one of the first times I've sort of been placed in this
So
position.
do you think that the court should decide it?
It is a timely issue.
But
And
you
we
think
do-
the court should decide it one way and not the other way, right? I mean, if
Well,
we don't grant the government's motion,
Mhm.
then we're going to decide the merits one way or the other. And
Yeah.
your client obviously doesn't want to take the risk that we're going to decide it a certain way, right?
Well, and the court still has to look to his other issue in the sufficiency argument as well, which we also feel there was not a sufficient amount of evidence to show that he violated the transportation exception.
So to be crystal clear, you are arguing in the alternative. You support the government's motion to vacate, but
Yes.
should we decide to reach the issue,
Mhm.
you support the unconstitutionality. You would argue for the unconstitutionality
Yes, I
of the
would.
statute.
If the court has no further questions, I'll cede my time to PDS amicus counsel.
Thank you.
Good morning. May it please the court. Alice Wang on behalf of the Public Defender Service as amicus curiae. I intend to reserve 1 minute for rebuttal. PDS agrees with the United States that Mr. CARRUTH's conviction for carrying a rifle should be vacated because the underlying statute violates the Second Amendment. And we think that conclusion is obvious from Heller and Bruin. The statute is a general ban on carrying long guns in public, and Bruin squarely held that there is no historical tradition of broadly prohibiting the public carry of commonly used firearms. Bruin recognized a tradition of banning concealed carry, which the district relies on, but concealed carry bans were constitutional only insofar as they allowed open carry, and they didn't interfere with the right to armed self-defense. Here, the statute broadly prohibits public carry and has a limited exception for transporting a gun when unloaded and inaccessible. But that exception makes it impossible to use the gun for immediate self-defense, just like the trigger lock requirement that Heller struck down as facially invalid. The firearms regulation that the district cites at pages 23 to 26 of its brief do not establish a historical tradition of banning long guns in public, or even of requiring travelers to disable their firearms. The district cites at page 24 an 1871 Texas ban on public carry that Bruin already rejected as an outlier. That ban also had an exception for travelers carrying guns with their baggage and did not require the guns to be unloaded and inaccessible. The district also cites an 1837 Maryland law that prohibited having an offensive weapon or gun in an open boat within 50 yards of any blind for shooting fowl, which the law deemed prima facie evidence of intent to shoot or molest said wildfowls. That's obviously not a ban on public carry or even a ban on transporting operable firearms. The district cites an 1816 Pittsburgh City Ordinance, making it unlawful to carry more than 30 pounds of gunpowder in a cart or wagon unless secured in a bag. That law allowed people to have less than 30 pounds of loose gunpowder to use in immediate self-defense.
Counsel, can you explain the relationship between 4504 and, well, the carrying statute and the transportation statute?
Yes.
So what makes this carrying and not transportation? And if it's transportation, then we've got the issue of sort of the safe harbor.
What makes this carrying is that he was charged and convicted under the statute that prohibits carrying a long gun. Now, that statute recognizes exceptions, which are in 4504.01, which gives a person who has a valid registration authorization to carry it in 4 situations: in their home, while being used for lawful recreational purposes, while it's kept at their place of business, or while it's being transported for a lawful purpose as expressly authorized by the districts and the federal statute. So there is a separate crime of unlawful transportation of a firearm, 224504.02, but Mr. CARRUTH was not charged or convicted under that statute, because it hadn't been enacted yet. That was enacted in after his conduct in this case. So he's charged only and convicted only under 224504A-1,
Right.
which just reads, except as otherwise permitted by law, no person shall carry within the District of Columbia a rifle or shotgun.
He defended on the grounds that he was lawfully just passing through, right?
Well, he defended on a number of grounds. One, that he wasn't carrying because he didn't have it accessible.
Right, but he did.
And that
so.
he also tried to defend under subsection 4 because although he didn't have a valid registration certificate, so that exception didn't apply to him.
But I'm saying he presented that defense. That defense was presented to the jury,
Yeah.
which obviously rejected.
That's right.
it.
That's
Yeah.
right. So we think that even if you were to, we think that it's pretty obvious that just the plain language of this statute, it's a general ban on public carry of long guns. But even if you were to construe it as a ban on carrying an operable and loaded firearm while traveling, there's still no that would violate Heller, because Heller invalidated a trigger lock requirement that was effectively the same thing, but at home. And as I've been discussing, none of the district's historical examples provide precedent for such a ban, that people who are transporting or traveling in a car have to disable their firearms to the extent that they can't use them for self-defense. None of the laws that it says. So to the extent that they do cite any such laws, pages 24 to 26 of their brief, which is laws regulating guns in trains and cars, most of those did not require the guns to be unloaded and inaccessible. And the only two that did, a 1929 law from Iowa and a 1919 law from Maine, were enacted more than 120 years after the Second Amendment was ratified, and thus shed no light on its meaning.
So, counsel, I sorry to interrupt you, but so you're arguing the merits of the constitutionality question. All parties, and you are not a party, but as amicus, agree with the position that the statute is unconstitutional. Why should we not grant the government's motion to vacate the conviction, remand for dismissal in the interest of justice using the language of 17306?
Well, two things. First, not all the parties agree. The district vehemently defends the constitutionality of its statute. So there is a live dispute in this case about the constitutionality of the statute. I agree with you that there's no party arguing for affirmance in the sense that the district doesn't oppose the United States motion to vacate. But the reason this court, I think that if the court agrees with PDS and the United States that the statute is obviously unconstitutional, and we think it is obviously unconstitutional under Bruin, which already said there's no historical precedent for banning public carry. And as I just went through, the district doesn't cite any law even close, historical law that would justify it.
Public carry period, or public carry for self-defense?
Public carry of commonly used weapons.
Commonly used weapons.
Yes, that's the language in Bruin. And Bruin, of course, was talking about pistols, but in fact, historically, rifles and shotguns were regulated less strictly than pistols were.
I guess my question is, so I understand your point about the district, but you just said that all parties don't support affirmance. So how is it in the interest of justice? I mean, at the point where we deny the government's motion, then the issue is live before us on the merits. And at that point, we could end up affirming the conviction, right? Finding the statute constitutional, finding the evidence sufficient, and affirming the conviction. How is that in the interest of justice when all parties agree against affirmance?
I completely agree. It would be against the interests of justice to affirm when all the parties agree that affirmance should not occur. However, I think that if the court agrees with us that the statute is obviously unconstitutional, it is in the interests of justice to say so, because even though the United States has stated that it will no longer prosecute violations of this statute, the law is still on the books, and people who carry their lawfully registered long guns in public will still be arrested. They will still spend a night in jail.
That's just not how the order of operations works, right? I mean, if we might have personal views about whether the statute is constitutional or not, but we're not going to consider those when deciding whether to grant or deny the government's motion as the order of operations. So if we grant that motion, we would be expressly and purposefully doing so without touching on the merits. And so if you're asking us to deny the motion, you're accepting on behalf of not your client, you're accepting the risk that we might end up affirming. And that doesn't, I don't quite get that. PDS is not taking this position in cases where you are representing the defendant.
No, we're not.
Right. So
Because
how
of
is
exactly what Mr.
right?
Ryder said.
But how is that reconcilable with your position that we are obligated to decide the issue?
Well, I don't think that there's any set in stone order of operations. The United States' motion to vacate actually doesn't say anything about whether, it just says that it's completely unfair and a miscarriage of justice for Mr. CARRUTH to be convicted of this crime. And we agree with that.
Because
it's unconstitutional.
Because they are of the view, as are you, that the statute is unconstitutional.
Right.
Right.
And so I'm saying that again, there's no written in stone order of operations. If this court
Well,
agrees
the order of
that is,
operations comes from how the judicial function works, right? I mean, we are not in the business of deciding merits in order to decide whether to do something before we decide the merits. Like, that's just backwards. That's not how we are supposed to function. So if we're granting the government's motion on the ground that all parties agree and that the government has agreed to dismiss the charge on remand, then by definition, we're doing that without an eye towards the merits. Again, we might have personal views about the merits, but if we're going to do that, I mean, I don't want to tell you how how the sausage is made, but we're not supposed to be conferencing on the merits of the constitutional question if we go back and we say we're going to grant the government's motion. So that just seems fundamentally unfair.
well, I mean, that's fine. I think we're here as amicus to say that there are people whose constitutional rights are being violated and that we think the statute is obviously unconstitutional. There's not really we think that
Their rights are violated because law enforcement hasn't gotten its act together as to whether or
Because
not
the-
that statute should be enforced?
because the Metropolitan Police Department isn't bound by the U.S. Attorney's Office promise not to prosecute, or statement that they don't intend to prosecute. The United States Attorney's Office is saying we're not going to we're not going to prosecute people for this.
See, so I'd like you to spin that out. I know you've done that to an extent. Normally there's a statute. Some people say one person challenges it, the other one defends it. Then some neutral arbiter, a court, decides it. Then everybody's bound by that, right? Unless it keeps going. And what's happening here is it's almost like there's this private consensus, the statute's unconstitutional, and so we're just going to not enforce it. Although, of course, the district comes in and says, no, we think it is constitutional. However, nonetheless, we think you should grant this motion. And I have questions about that. And in the U.S. Attorney's Office, I would like to hear from as well on why we should not decide this question, and whether, unlike a situation where the U.S. Attorney's Office can say, look, under separation of powers, we decide what to enforce, what not to enforce. This is our view. Absolutely correct. But this is different. Here, a properly constituted U.S. Attorney's Office with a different view, obviously, secured an indictment, prosecuted the case. It was presented to a duly constituted jury, which returned a conviction. Seems to me that there's been a whole proceeding under DC law and that the whole matter is invested with a public interest in, okay, what's the correct result as a matter of law as decided by the correct forum to make that decision? I mean, this is, I'm speaking to the choir here. I really want to be speaking to the others. But I would like that to be addressed, because it seems to me, it's almost as if the court is being asked to endorse kind of a private agreement, as if this were a commercial case and then there's been a settlement of the issue.
Yes, I agree with Your Honor that it is odd to me that the United States would come in here and argue to this court that it is a fundamental miscarriage of justice for Mr. CARRUTH to have this conviction because the law is facially unconstitutional and protects constitutionally and prohibits constitutionally protected conduct. And yet it's asking the court not to say so. That is strange, because you would think if they really believed that, they would want that to be the law of the district and in the interests of justice for no one to ever be convicted under this statute. And we think that's the right outcome. And we think that this court has every power to do that. And it should, in the interests of justice. The only reason not to do that, as the United States and the district say, is out of a principle of constitutional avoidance, which is just a prudential doctrine. And the interest in avoiding the question in this case is quite low when the answer to the question is so obvious under Bruin. And And we think whatever interest there is outweighed by the interest in avoiding unjust deprivations of liberty and having the public know what the law of the district is in accordance with the Constitution. So, I mean, I agree, Judge Schenker, that I wouldn't be arguing this if it were my client because of the small, whatever risk there would be of affirmance. But as amicus on behalf of the public, I'm actually quite confident that if the court were to decide the merits of the issue, it would decide the statute is unconstitutional, because based on what Bruin already said, there is zero historical justification for banning public carry of long guns. There just is nothing. So I don't think it's a close call. And I think that usually when the court avoids constitutional questions, it often says difficult constitutional questions, because unless you have to decide it, you don't want to risk making the wrong decision. But here, where the United States, the prosecuting authority, has affirmatively argued that the statute is facially unconstitutional and that every conviction under that statute is a fundamental miscarriage of justice, then the risk of deciding it incorrectly is low, I think.
I would surprise you.
Yes, and you may surprise me, and then I guess Mr. CARRUTH could, seek a cert petition in the Supreme Court, and the United States wouldn't oppose it, and his conviction would be
Right,
vacated.
and that would be the normal course.
Yes, and I think that's the normal course of judicial practice, and I would also point out that while not binding in terms of order of operations, this court's internal operating procedures state that when a case gets to a merits panel, that the normal, order of operations is to issue an opinion, not to issue an unpublished order. Most of the cases that the district cites, examples of the court vacating a conviction in an unpublished order based on a government confession of error, are usually motions panels that have not reached a merits panel yet. So, I mean, I'm not saying the court is bound by that. It can. I think it's in control of its own internal operating procedures. If the court wishes to deviate from it, I am in no position to say that it can't. But we just think that there's a real public interest side. That, of course, no blame to Mr. CARRUTH, who has no interest in vindicating the public's interests. He's interested in his own interests, and that's fair. But we as amicus are here advocating on behalf of the public for the court to reach the very obvious answer to the constitutional question here, which is that the statute's unconstitutional, so that people can avoid unfair and unjust deprivations of their liberty for exercising their constitutional rights. Thank you.
Thank you, counsel.
Good morning, and may it please the court. Dan Lenners for the United States. I have ceded 5 minutes of my time to the District of Columbia. I'll start with the vacatur issue and then turn to the Sixth Amendment issue. To clear up any misunderstanding, the United States has no ultimate objection to this court publishing an opinion saying that the carrying a rifle statute is unconstitutional and violates the Second Amendment. However, the United States nonetheless believes the court should not do that and should instead vacate Mr. CARRUTH's conviction to avoid any possibility of an affirmance. That is why the government moved to vacate Mr. CARRUTH's conviction. The Office of the Attorney General has put forth numerous arguments for affirmance, some of which would not lead to a merits determination. They have argued, for example, that Mr. CARRUTH waived his Second Amendment challenge by failing to timely raise it below, and that he's forfeited it by not properly briefing it before this court. This court could also decide the case on the sufficiency of the evidence without reaching the constitutional issue. And so to avoid the possibility of an affirmance and to, I guess, take the burden off the court to have to decide those complicated and challenging issues before addressing the Second Amendment issue, which the canon of constitutional avoidance suggests the court should, the government believes it's in the interest of justice to vacate Mr. CARRUTH's conviction without wading into that morass. And that is the just outcome here. And the government separately believes that Mr. Carruth's convictions for unlawful possession of a firearm and unlawful possession of ammunition should be affirmed because there was no Sixth Amendment violation.
So generally, when we vacate convictions, or I guess I should say, as the judicial function in vacating convictions is based on a finding of some sort of error. As Judge Ruiz says, there's a jury determination here, a jury conviction. And for us to undo that should require some finding of error. So if we were to do that without finding error, I mean, I see the constitutional avoidance point, but that might be, I mean, if we were to decide to vacate the conviction on another ground, that would allow us to not reach the constitutional question. That seems to implicate constitutional avoidance, but not simply declining to decide whether there was error at all.
So courts routinely vacate convictions at the government's request without finding any error. I mean, the Supreme Court repeatedly did it when the government found violations of its internal pettit policy, which is not any sort of error at all. There's no constitutional question or statutory issue with prosecuting a defendant for the same crime federally that he was convicted for in a state trial. The United States nonetheless repeatedly in the 70s asked the Supreme Court to vacate those convictions and remand so that it could dismiss them. And there are other instances in the cases cited in our brief where, for example, the prosecutor developed serious doubts about the defendant's guilt. And so the government moved on appeal to vacate the conviction. So I don't think this court needs to find any error to agree that when the prosecutorial entity has determined that the underlying statute is unconstitutional, will not prosecute people for that crime going forward. And in the trial court has engaged in sort of similar efforts to erase convictions or get people out from probation who were convicted under this statute, that it is in the interest of justice to vacate that conviction without needing to say anything about the merits. And the court has done that in other cases involving the large capacity ammunition feeding device. I don't remember the name of the case, but I know that there was a recent published opinion where the court addressed the other substantive issues, but because the government had moved to vacate that conviction and no one had opposed, the court simply said in a footnote, we're vacating the conviction. So
Miller case.
I'm sorry, Your Honor? Yes, Your Honor. And so the government thinks the court should take the same approach here.
But there wasn't that opinion doesn't really discuss any of these issues we've been talking about here, about the need or wisdom of addressing the merits.
That's true, Your Honor. There's no binding precedent that I'm aware of that would preclude the court from taking the path that the Public Defender Service has suggested. But I would point out that I'm not aware of any case taking that path, which I think counsels against the wisdom, counsels against doing so because the court would sort of unnecessarily be deciding both the non-constitutional issues that it would have to resolve in Mr. Carruth's favor to then get to the Second Amendment issue. And the government doesn't want that outcome. We don't want this conviction to be affirmed, even if the court were to say, for example, that Mr. Carruth waived the challenge by failing to properly raise it below. We think there's significant merit to that argument made by the Office of the Attorney General, but we're not seeking an affirmance on that basis because we think the statute's unconstitutional and therefore that the just result is to vacate the carrying a rifle conviction.
In cases where the government has moved to vacate a conviction because, as you said, one was internal policies had not been followed, right? To me, that kind of falls more squarely in this notion of, well, as part of our prosecutorial discretion, the way we have decided we normally proceed, this prosecution should never have been brought in, so we're taking it back in that sense. Or where you have serious doubts about the sufficiency of the evidence. It's almost, I don't know whether it's an actual confession of error in the trial court, but it seems to come closer to that. This one just feels different to me because it's such a pure legal issue and a constitutional one. That really should not be the subject or the purview of parties to a case to make a final determination on, because this question then is still kind of hanging out there, right? Is this statute constitutional or not? You may move to vacate. This U.S. Attorney's Office may decide not to prosecute, not to bring, not to enforce it going forward. But this U.S. Attorney's Office may not continue, that same view may not continue into the future. And then where are we then? Maybe we have, well, maybe the Supreme Court will say some more things that will clarify things even more. Or maybe then there will be a conviction, a prosecution and a conviction that comes up to us where there's a straight challenge by the appellant, and it is, and the statute is in fact defended by the government. Is that?
So I, of course,
How do you
can't,
see
I of
this?
course can't bind, the U.S. Attorney's Office.
No,
in the
no,
future.
that's my point.
It is the government's position that the
At
statute
this
is
time, yeah.
unconstitutional. We've set forth the reasons, and we think those reasons will always be true. I think the court's instinct as to why this feels different might be because it feels more important, because it's a constitutional challenge to a statute. But I think that's exactly the reason the court should avoid determining it. I mean, that's what the canon of constitutional avoidance counsels in favor of, is avoid those hard, or those constitutional important issues if it can be resolved on narrower grounds. And this could come before the court in a way that it's cleanly presented. The Office of the Attorney General believes the statute is constitutional and may well prosecute juveniles for violating it. And the juvenile could properly challenge that charge below. And if the trial court thinks the statute's constitutional and the juvenile is convicted, it could come before this court properly and cleanly presented. So it's not as though the government is trying to avoid this court determining the issue. As I said, the government has no problem with this court publishing an opinion saying the statute's unconstitutional, but we want to avoid the injustice that Mr. CARRUTH would face by having an affirmance, or even the risk of an affirmance, which is why we've moved to
Well, it would
vacate.
only be an injustice if you were correct on the constitutionality of the statute. It would not be an injustice if we disagreed with you and,
I'm not sure that's right, Your Honor. I mean,
well, you
we aren't-
say it would be an injustice. Why would it be an injustice? Because you were willing to give up to concede that, I don't even know how to put it. Why would it be an injustice for Mr. CARRUTH to remain convicted under a statute that was found to be constitutional?
because he would be the only person convicted under that statute, because the U.S. Attorney's Office is no longer prosecuting people. Other people who have been convicted of that crime in the trial court, the U.S. Attorney's Office has agreed, for example, to end their probation. And so I think it would be an injustice, because ultimately the prosecutorial entity that has discretion to bring and maintain these charges decided that he should not stand convicted. And so regardless of whether this court were to think the statute's constitutional, I think it still would be an injustice to Mr. CARRUTH, where, and in addition, everyone sitting here today thinks his conviction should be vacated. There's not a single person on this side of the bench that thinks that there's any other just outcome. And so for that reason too, we think it would be an injustice.
Counsel, I know we've taken, sorry, do you have more questions on this?
I had one.
Sorry, after this question, I know we've taken you over time. I'd love to hear your points on the Sixth Amendment issue as well.
Your Honor.
But just, you would not think it would be an injustice if, for example, and I'm not saying we're there, but we were to find the evidence insufficient to support the conviction. Right? I mean, that would be.
That would not be an injustice, because he would not stand convicted.
Right.
That's right, Your Honor.
And so that would be sort of equal in your eyes as an outcome to granting your motion to vacate.
As an outcome, yes, Your Honor. But again, we've moved to vacate to just avoid the risk of an affirmance. And we think that is, that's the just result in what the court should do here. On the Sixth Amendment, Your Honors, no court that we're aware of has found the type of order at issue here, which is an order not to discuss your testimony with your attorney during a lunch break that occurred during the defendant's cross-examination violates the Sixth Amendment, and we think this court should not either. In terms of the nature of the order, I don't think defense counsel characterizes it correctly in his advocacy for calling it a blanket prohibition on communication. I mean, the court was quite clear that that the defendant should not be speaking to his lawyer about the substance of his testimony during the break. And his attorney said, I have an absolute right to talk to my client about anything, including his testimony, which is just not consistent with the Supreme Court's holding in Perry. The court said, don't discuss your testimony with anyone. So this properly understood, this order was limited to Mr. CARRUTH discussing his testimony with his attorney, and it was limited in duration to the lunch break. And we think that those two factors distinguish this from the overnight recesses in which attorneys have been told, or defendants have been told not to speak to their attorneys, and is more consistent with the shorter recess at issue in Perry. And
So, I mean, your answer will probably be you don't need to reach this, but in Perry, the notion was, the order was do not talk to anyone, including your lawyer. It wasn't narrow, it wasn't specific to about your testimony, but it was 15 minutes. And the court's reasoning was that what the heck else are you going to talk about during those 15 minutes in the middle of testimony? Would you say that the order here could be defended on that same basis? Or is it enough that the court's order was explicitly about testimony?
Yes, I think that this could be defended even if it was a blanket order. That's the kind of order that the Second Circuit looked at in Triumph Capital Group, that the Third Circuit looked at in Horn. And in Horn, the Third Circuit specifically found a 2-hour prohibition over lunchtime to be likely tolerable under Perry, insofar as the sole topic of discussion would have been the testimony itself. And that's what the Second Circuit focused on in the Triumph Capital Group case, which is it's not so much the length of the break as it is what do we expect the attorney to talk to his client about. And if it's a short enough, if it's sort of during the day, during cross-examination, it occurs over lunch, we think the sole topic of conversation is likely to be the testimony. And therefore, under those circumstances, a flat prohibition on communication would be appropriate. But again, we don't have that here. We have a more limited, don't discuss your testimony with your attorney. And as the Supreme Court made clear in Perry, when a defendant becomes a witness, he has no constitutional right to consult with his lawyer while he is testifying. And so we think that this, as every court I found has held, this prohibition over the lunch recess comported with the Sixth Amendment.
And do you think Villarreal might change that landscape in any way?
It could, and I think it would be the appropriate course for this court to wait for the Supreme Court to decide Villarreal before it decides this issue. The Supreme Court heard argument in October and will decide that case by June at the latest. So I think regardless of what the court's instinct is how to decide this issue, the wise thing to do would be to wait for Villarreal.
If you were working on a blank slate and it wasn't necessarily the specific facts of this case, how would you draw the lines? You've hinted at it some, that it's more about the topic and the narrowness of the restriction more so than the time length, but what do you think is a good line, or is there just no possible bright line here in your view?
I don't think there's a bright line, Your Honor. As I said, the courts who have looked at this have tried to look at where the break occurs, when it occurs, how long it is, and to think about what is likely to be the topic of discussion. And if the sole likely topic of discussion is the defendant's testimony, then the prohibition is appropriate. And that's why I think the overnight recess cases are readily distinguishable, because the courts have focused on that's a time for trial preparation, strategic discussions, discussions of jury instructions, and other more substantive information that the client does have a right to discuss with his attorney. So yes, there's no bright line in terms of time. It's more about what the expected substance of the conversation will be.
Thank you, counsel.
Thank you.
Good morning, and may it please the court. Brian Leach for the district. I'd like to start, if I might, with where Judge Schenker, you were picking up earlier with the appropriate course for the judicial function in this case, which we believe is to grant the government's motion to vacate. I want to be clear, the district's position is that it does not oppose the United States motion to vacate in this case in the interest of justice. We stand by the arguments in our brief, but we think the appropriate course is to do exactly what this court did in Miller and just last month in Robertson versus United States. In both of those cases, the court granted unopposed motions to vacate filed by the United States, despite Second Amendment claims being brought against district gun regulations. I think that's the appropriate course here.
Why?
Because, well, I can explain it from the district's perspective. We are not interested in second guessing the considered judgment of a co-equal prosecuting entity. And when the prosecuting entity decides it no longer wishes to pursue charges against a defendant, our view is that we are not interested in that's their prerogative. They should make that decision. We have a different view on the merits, but I want to make clear, our institutional concern, at least as it goes to this motion, is for the court to understand the scope of its authority to vacate convictions in the interest of justice without this purported obligation to rule on the merits in a precedential opinion, which was asserted by PDS in their filing. And I understood them to somewhat walk back from that today and acknowledge there is no such obligation. And I think Miller, Robertson underscore this point, as well as the cases we cited in our filing, two of which did involve merits panels, one of which involved in a concession of error on a constitutional issue. And this court nevertheless still did not reach the merits of it. And I think that's the appropriate, most efficient use of the court's resources.
You mentioned respecting the prosecutorial discretion of a different equal authority, the U.S. Attorney's Office, and they brought up that you, of course, the OAG could nonetheless prosecute juveniles under the statute. Is that correct?
That is correct. We could.
So we might have that situation in DC where the U.S. Attorney's Office is not prosecuting adults. But, oh, I'm so sorry. But everything is, but apologies for that. But the district would be prosecuting minors because of its view of the constitutionality, that the statute is in fact constitutional?
That is correct in part. We have the authority to prosecute juveniles under the statute. Our position as well is that in this court has picked up on it in the Picone decision, where juveniles have either no Second Amendment rights or reduced Second Amendment rights, given their status as infants in the eyes of the law. I would acknowledge the fact that it could arise again in another context, I think is all the more reason for this court to stay its hand in this case, not decide the merits unnecessarily. I mean, that is the core principle of not just constitutional avoidance, but it goes to a deeper principle of judicial restraint. And what this court has said is discretion is often the better part of valor unless it's absolutely necessary to reach a constitutional question.
Counsel, let me ask you a question. As a judge who was on both Miller and Robertson, which was a published and an unpublished decision, those are different charges in those cases. Both of those involve large capacity ammunition feeding devices. Your opposing counsel or amicus raised an argument that what could look like a blanket ban on long rifles just isn't that close of a question compared to, I think we could all say, large capacity ammunition devices. may have some corollaries. I understand we have other cases where we're looking at this, but it seems like it, at least from their perspective, a more arguable question. How would you answer that? And perhaps that's the reason we didn't delve in and that merited the avoidance more so than this question, which they categorize as a pretty easy one, contrary to your view.
Sure. A few points on that, Your Honor. The first is that this facial challenge that PDS has asserted, there's no dispute that was never raised in the trial court by CARRUTH. There are arguments about what he exactly argued regarding the Second Amendment. There is no dispute. He never raised a facial challenge or a challenge to the idea of this statute being a flat ban. We would dispute that characterization to an extent, but so you're reviewing this, if at all, for plain error. It could entirely be unreviewable. And I particularly think is inappropriate to have it reviewed when it's raised only by amicus in the first instance. I mean, if you look at CARRUTH's two opening briefs, he says nothing about a facial challenge to the statute or a challenge that this is somehow a limitation on his right of public defense. He raises, the argument he raises in his opening briefs is there is some sort of non-existent registration requirement for traveling through the district with a firearm. That's the claim he raised. Now, in a supplemental reply brief, he tries to appropriate amicus's argument. But the only reason he got a supplemental reply brief is because he didn't comply with Rule 44B at the outset of the case. It provided the district notice that a constitutional challenge had been brought to one of its statutes. So I don't think he should benefit from the opportunity to raise it in a supplemental reply. But the second point I would make is that one thing you did not hear from PDS is engaging with the high bar for facial challenges. They have to show, as Rahimi made clear, it's unconstitutional in all of its applications. They can't show that, and they can't show that for a reason that's clear from their own brief. I mean, the argument we make in our brief is that it's not facially invalid because it's validly applied to CARRUTH in this case, and therefore it can't be facially invalid in all of its applications. But their own brief acknowledges that at common law, it was a crime to go armed for the purpose of terrorizing the people. That would be an historically justified application of the district's statute, even under their characterization of the law. If someone were driving through the district, even with an unarmed rifle, and were brandishing it to the terror of the people, that would be a valid application of the statute under Rahimi. That would be enough for the statute to pass constitutional muster.
Even if the statute reads much more broadly than that, when
Yes.
you're talking in any of its applications, and this is a question I had, to what extent does one don't we just have to take the statute as it's written?
There's two.
Which it only has those except as permitted by law?
You would look at the entire statutory scheme on its face to be sure. I think one of the difficulties about facial challenges, and the Supreme Court made this crystal clear again in Net Choice just 2 terms ago, that you really have to engage with how is this law going to be applied in all of its applications. And Rahimi made clear in the Second Amendment context, you need to be looking for the opportunities for where it would be valid, not seeking to ferret out conflict between the statute and the Constitution. When you take that analysis here, you could find multiple ways in which the statute would be applied validly. I do want to dispute one point, though. My friends from the PDS have argued as amicus that this is somehow obvious under Bruin or under Heller. But I think what they're trying to get at is the fact that they know this is going to be reviewed only for plain error. The problem is their argument in their filing on this describes this as a question of first impression. Now, a question of first impression under this court's precedents cannot be plain or obvious error. It has to be an error that's clear under the law at the time. So if it's a question of first impression, it can't be obvious under Bruin or Heller. And I think part of the reason for that is if you look at the trigger lock in Heller, it applied in the home to any type of firearm. In particularly in that case, the most popular type of weapon, which was a handgun. The requirements here apply to rifles. They do not apply to every form of a firearm in the district. They allow as well for public carry for self-defense in the home, as well as in someone's place of business, which is often going to be a public place. Additionally, there's public carry for lawful recreational purposes. You can transport it for a lawful purpose so long as you comply with the transportation regulations. All of those factors combined, I think, suggest that, particularly as applied to CARRUTH, there was nothing unconstitutional about this regime. But these are all questions that I think are better suited for a case where, first of all, the defendant raised the particular challenge at issue cleanly in the trial court, usually in a Rule 12 motion to dismiss pre-trial, and that they clearly raised it on appeal in a brief that wasn't just a cryptic paragraph at the end of their brief and a cryptic paragraph at the end of their reply brief related to, again, a registration requirement that does not exist in district law.
Well, those are reasons to not reach the merits. I agree with you, but they're not reasons to not reach our decision not to reach the merits, right? So why isn't the district supporting a decision, published or unpublished, that says these claims were not properly preserved, whether below or in this court, and so we affirm
We recognize.
without reaching the
Sure,
constitutionality?
sure. So a few points of response, Your Honor. We stand by the arguments in our brief, but we recognize as an institutional matter that this court's resources are probably best used, not spent trying to decide the merits of this case, whether it's on the merits of the procedural issues or on the substantive Second Amendment claims. And, you know, you highlighted earlier, Your Honor, the potential anomaly that comes from PDS's position, which is that you deny the motion to vacate and affirm the conviction in a case where the prosecuting entity and the defendant have both agreed and are moving to vacate the conviction. We think that would not be, we think that the court should avoid that type of anomaly as an institutional matter. In the interest of candor, that's our best considered judgment on the issue. And again, our primary concern is for this court to understand the scope of its authority under 17-306, because there are a lot of cases where the district confesses error or files a motion to vacate because it doesn't wish to pursue the charges anymore. And we want the court to understand that it has the authority to grant those motions, even after oral argument, as it did in Miller, when the court finds that the remedy is just under the circumstances. And if the court has any further questions, I'm happy to answer them, but otherwise we would rest on our briefs.
Thank you, Mr. Leach.
Thank you, Your Honor.
Thank you, Your Honor. Keeping on the subject on the Sixth Amendment, I'd like to respond to the arguments of the United States. They're relying heavily on Perry. Perry does not apply here. This was not a short break. This was a lunch break, which this court has commented on in terms of a significant break in a prior case of Jackson. But more importantly, what I did not hear in the United States brief or argument here is that their position, as it was in Villarreal, you cannot have coaching and management of a witness. What does that mean? There is no definition. I think in the Villarreal, they said, you can't discuss testimony, but you can certainly always discuss a plea offer or a plea agreement or your belief on it. As an attorney, how does that leave me? I go back into the dock. There's a significant break, whether it's overnight or in this case, a lunch hour. And I say to the defendant, you know what? I think it's time to take a plea. And he says to me, why? I don't know what to say for fear of violating the order. Again, that absolute right to a Sixth Amendment consultation with full functioning counsel should overrule any sort of fear here of coaching and management. And I'll just leave, sorry, apparently I'm here today, but my voice is not, is that no attorney worth their salt does not put a witness on the stand, let alone a defendant, without thorough preparation. So the whole management theory really doesn't hold water here. That's our opinion. Again, it's just not practical. And because there's not been any definition, I think this court can decide that this is a per se violation. It was plain error and not conducive to review under Chapman versus California.
Thank you, counsel.
I do want to address the preservation issue because I didn't get a chance to do that in my main argument. The Regardless of whether the Second Amendment challenge to the indictment was timely below, it was ruled upon. And that makes it, nothing in Rule 12 says that if the court actually rules on it, on the merits, that Rule 12 simply says nothing about preservation for appellate purposes. And as for, Mr. CARRUTH challenge in his main brief raised the claim that his conviction violated the Second Amendment, and he made effectively two arguments in support of that claim. One, he said that Bruen recognizes a right to public carry, and two, he said that a non-resident shouldn't have the burden of registering. And then PDS filed a brief developing and supporting his first claim about Bruen. And the United States has now filed a brief also supporting Mr. CARRUTH's argument about Bruen, and no one has argued that's waived. This district had ample opportunity to respond, and it spent 6 pages of its brief citing historical regulations that it purports, to be justification for the statute. So the issue is fully briefed. There is no prejudice to anyone, any untimeliness. The prejudice has been cured by the opportunity for briefing. And so it would be, it's really, regardless of the intricacies of the preservation arguments, that's not a reason to not decide the issue. As to the district's argument about how PDS has a burden to show that the statute is valid in all of its applications and that it's not validly or that it is validly applied to Mr. CARRUTH, because I didn't quite understand. They cited something about how there's historical justification for prohibiting people from carrying weapons to terrify the people. There's been no allegation that Mr. CARRUTH carried his weapon to terrify the people. He was just carrying his rifle in a car, full stop. And there's no historical justification that the district has cited to support that. As I had mentioned earlier, none of its Bruen has already said that there's no historical precedent for banning public carry. And even the examples that the district, painstakingly cites in 6 pages of its brief, none of them bar people from transporting or traveling while having operable firearms on them. This sort of as applied versus facial distinction really doesn't make a difference in this case. The test is the same. The Bruen test is that and this is what Rahimi said, when the government regulates arms-bearing conduct, the government bears the burden to justify it with history. That's the test. And the district has attempted to justify it with history. We've explained why all of those attempts fail, and that Bruen already answers the question. So it is an easy question. The preservation issues are not an obstacle. And so while we agree that this court has the power to vacate the conviction without deciding the issue, that doesn't mean that it should do that. We think it should hold that the statute is unconstitutional in order to prevent unjust deprivation of liberty.
Can I just ask, so is it your position that the mere fact that the court ruled on a late breaking and undeveloped, my editorializing, motion to dismiss on Second Amendment grounds renders the issue fully preserved in the trial court?
Well,
I mean, we've said, so that the historic language on 12b-6 is waived if not raised before trial. I think we clarified in 2 maybe that
Yes.
we don't really mean waiver, we mean forfeiture. So that would subject it to plain error review, unless your argument is that the mere fact that the court decided the issue takes it also out of plain error review. Is that your position?
yes, because in Chu, not only was it not raised before trial, it wasn't raised in the trial court at all. Chu was a case where the issue was raised for the first time on appeal. And even then, the court said, that's just plain error. Now, we think the error is plain, but when I said it was obvious, I actually wasn't trying to advert to plain error review. I was just saying that it's obvious, so that's why this court should feel confident in doing it when it has discretion to avoid it. As to the Rule 12 issue, the district cites only one case from this jurisdiction, which is Federo. And that's completely not on point, because in Federo, the trial court denied the motion as untimely under Rule 12 because it wasn't raised pretrial. And then this court affirmed. I mean, that's fine. That doesn't address the issue here where it was untimely under Rule 12, but the trial court, the government didn't object on timeliness grounds. And then the trial court went ahead and decided on the merits, effectively excusing the timeliness problem. And so now you have a ruling on the merits. And by the way, this is a pure legal issue. There's no factual development. I would agree that if, because of the timing of the motion, there wasn't an opportunity to develop necessary facts, that this court could say, that the issue isn't proper or, ripe for appellate review because we're lacking a factual record or something like that. But what Mr. Carruth's counsel said was, Bruin's been decided. There's a right to public carry. Now, he didn't file a written pleading, but sort of the basic claim is just, Bruin says there's a right to public carry. There's a problem here with my prosecution. And I think that's enough to preserve the issue, especially in this court where everything has been briefed and nothing turns on facts or the trial court's discretionary call or anything like that.
I see no further questions. Thank you to all counsel for your thoroughly prepared argument and extensive briefing in this case. The case is now submitted and we stand adjourned. All right.